Shame on you the first time. Shame on me. Putting people in harm's way after we know what we know now. Shame on me for giving you a third chance.
I want the truth. You can't handle the truth.
You were charged with the first degree felony of aggravated assault, date, family, house, relationship with weapon. Essentially, you are alleged to have committed aggravated assault and the complainant was a person you were in a dating relationship with. And it's a first degree felony, which means you face no less than 5, no more than 99 years confinement in prison or life imprisonment. A fine up to $10,000 can be assessed. I've reviewed the probable cause affidavit, which is very succinct. It doesn't give a lot of details. Your bond right now is in an amount of how much?
Judge, he had a bond set after this offense by the magistrate.
Of how much?
I think it was, your original bond was 10, they increased it to 50. I think it was,
What's his bond in this case?
I'm looking, Judge.
It's currently no bond.
there's no bond in this case.
What's okay? So how did it wind its way to no bond?
Well, what happened,
He
Judge,
removed the
is
GPS.
he had a GPS monitor on and he was confused as to the importance of the GPS monitor, and there's some confusion as to whether he could take it off or not after his protective order expired. And he didn't have a lawyer at the time, at least one he was in communication with. He understands now, I've gone over this with him about the importance of maintaining his GPS monitor and also no contact with the victim.
You got a no bond, Judge.
He would ask the court to set a bond so he could get out. He's concerned. He doesn't want to contact his wife, but his wife.
What was the history of the bonds? That's what I'm curious about. How much were they?
I can't find that amount, Judge. With the new system, it's hard for me to determine the exact amount.
Charlie, how much was your bond for 30? 30.
Yes, sir.
30, and it went to 60 with the.
The last bond that I showed before the no bond was 60.
50?
60.
60 was the
Must
last
have been
one before
30,
the
then
no bond.
doubled for some reason,
Well,
I guess, because 60 is an odd amount.
they added 30 and then they increased it to 60 and then added the after the DA picked up the accusation. I don't know exactly what happened during the period. He understands he wasn't supposed to take the GPS monitor off. He will not do it again. He's got a medical issue that he'd like to get taken care of. He has a hernia that is near.
You're appointed on this?
I'm hired, Judge.
You are? Okay. Okay. I'm saying that because there was an affidavit of indigence here that's not filled out and it says, why not? And it says you were uncooperative with the people. Then I was just curious.
I believe he has funds available.
Then it says, will inmate hire own? Yes. So I guess he did that. The Judge Collins on June 14th of 2023 set the bond at $60,000. And do you remember being in front of him, Judge Collins?
I went to an arraignment with a gentleman, does he have white hair? I can't remember if it was.
We all have white hair.
He was released June the 15th,
All right,
and it shows a $60,000 surety bond.
50,000.
60.
60.
Okay. Fine.
I submit that that's justified initially at that amount, Your Honor, because one of the underlying misdemeanors, the very first one against the same victim occurred. The offense date was August 13th of 2021. So he was out on bond whenever this felony offense that you're looking at is set in that regard. And I know that's important to Your Honor, so I wanted to interrupt to let you know that that's part of our fact sequence. In addition to that, Judge, there are 2 other misdemeanor offenses that are alleged that occurred after this offense date that you're looking at. Both are violations of protective order in regards to the offense that's alleged all the way back to August of 2021. All same victim.
Is it the same complainant in this 23 CR? Oh,
And that
okay.
she's been in contact with me today.
Oh,
She's in fear for her life and.
all right. Well, according to the state, he is arrested and charged with his first-degree felony of aggravated assault. And he is placed into custody on or about what? June what?
The date that June 11th of 2023.
June 11th is when he's arrested prior to indictment, I guess.
Yes, sir.
Then he is indicted on June 28th, about 2 weeks, a little over 2 weeks later of 2023, after he is arrested for the first time. And then after the indictment comes out, June 28th, how many other events, which all bond conditions have no contact with the complainant, commit no crimes, they're in all bond conditions. How many separate occasions is it showing that he violated those bond conditions?
2 separate charged events, Your Honor.
What are the dates, please?
Those dates. There are a date in July and a date in August, but let me get you. the
Okay,
specifics.
that's okay. Subsequent to him being indicted, subsequent to the arrest, subsequent to the later indictment, about 2 weeks later, he is being arrested and charged with 2 violations.
2 separate violations.
Which are, what were the arrests for, please?
Those are violation of protective order.
Can you respond to that? How we're supposed to be able to protect people and release him on bond when he's having contact with people and being charged with protective order violations? That's very serious.
Yes, sir. I
No. You made a promise when you first got out you would. Sir, subsequent to that, you've been charged with 2 separate offenses of those violations. Huh?
My wife's been in and out of the hospital.
I'm sorry?
My wife has been in and out of the mental hospital.
What does that mean? What does that mean? That she can be violated
Sir.
Well, the grand jury thought otherwise, didn't they?
Yes.
Okay.
And I have never done anything.
One of the things is also GPS angle monitor. What was that? Did you tell me that the angle monitor was
It
taken
was
off?
removed, Your Honor. That's what resulted in the no bond. And
I thought it was.
You thought it was what?
The 90 days I called and I thought it was.
Who did you call?
The bond, the ankle monitor company, Johnny's U-Haul. and
Yeah, we'll have them here too.
Yes,
We're gonna have a hearing on this later this week.
Prior counsel
Yeah.
got off of this case behind the
He's
accusation.
talking about it. He's talking about it. And it's other people's fault.
No,
We're
sir.
gonna,
It's my fault.
are you gonna interrupt?
No,
You'll have a chance to be heard. We're gonna have a hearing on this. I want some witnesses here because we're talking about the Constitution and right of bond. But I can guarantee you, I'm not gonna release you right now when there's substantial information before me that you can't follow the conditions of bond. You're contacting the complainant, you're sawing off or taking off your ankle monitor. Those are things that don't happen. And when they do, they're dealt with severely. I'll have a hearing on this Wednesday. I did give everybody 48 hours. Okay, we'll set a hearing on that. But when you're doing that, if it's found true, you're not gonna, there's no conditions of bond I can set because I have to rely on you to follow what the rules are. And when you don't, especially contacting or taking off devices improperly, I'm gonna want Johnny's up here to explain to me how they approved that.
He's not saying they're.
No, he's saying, he's saying other people. He's using other people for the responsibility of his decisions. We're gonna get everybody involved and once again, I'll make a decision. But you're asking for relief, and if it's all your fault that this is happening, how can I say, okay, you'll have another chance? And then say if something bad happens, it would be not shame on you, it would be shame on the idiot judge under these circumstances that released you when you couldn't follow the rules. I mean, if this is serious, these are
Ever.
What's that?
I'll never make a mistake like that.
Oh wait, what a mistake.
The mistake of cutting that off after the 90.
Well, okay,
a mistake. of
10 minutes
going to
before
my
you-
house When I shouldn't.
I'm sorry, 10 minutes before you did that, if I'd have asked you, are you going to make a foolish mistake by cutting this thing off? What would you have said?
Absolutely will not do it again. It was
No,
not a
what would you have
mistake. It was
said?
Absolutely wrong.
What would you have said? If I'd asked you 10 minutes before you did it, are you going to really do that? What would you have said?
Never gonna do it again.
No, what would you have said before you cut it off? If I'd have asked you that? Are you about to cut your GPS monitor? What would you have said to me?
No, sir.
You'd have lied to me.
No, sir. I would have never lied to you.
You would have lied just then.
Wait. Are you saying, I don't understand the question. I'm sorry. I'm never cutting anything off my ankle ordered by a judge. I'm never going to disobey a judge's order. Not to go to my house. I'm never going to make a mistake.
You
or
did, but you
commit a
did that.
crime like that.
But you did that,
I
right?
absolutely did, sir.
Oh,
And I'm
okay.
sorry.
Okay. So how many free chances do you get?
No,
Oh,
I don't get any free chances.
you're
I've
right.
spent a
You
month-
don't.
Over a month in jail, and I'm sorry. Absolutely sorry.
Yeah. Bad choices have consequences.
Yes, sir.
But shame on you the first time. Shame on me. Putting people in harm's way after we know what we know now. Shame on me for giving you a third chance. Do you really think I'm going to open the door? What's fair for you is fair for everybody. Everybody gets third chances now? Or are you special? Then it's the same rules everybody has to follow, sir. It's a test. When you fail the test, you don't move to the front of the class. You fail, you get an F, and you have to pay a consequence. But I'll have a hearing on Wednesday, hear more evidence. But it doesn't, look, I'm not changing my past practice. You get a fair opportunity when you fail and showing that you can't be trusted while on bond, you don't get a bond again. Because it's a test all the time to see how you're going to do. You can't say, oh, now I'm really going to really follow the rules now, really. When you look the judge in the eye and said, yes, I would. In fact, you sign a document on the bond that says, I understand my bond can be revoked. Anyway, we'll deal with it.
For my subscribers who entered the competition for counting the number of times this guy said this,
And I have no reason to lie to you.
or something close to it, I will be announcing the winners and placing those winners into an episode as winners forevermore. There is still time to enter, as I'll close the competition the day before I select the winners. So I'll leave a link at the end and below if you want to have a chance to live in infamy. We are a crime channel, which is different than most, and that's all because of my subscribers. We are all just a little different, and that difference is what makes us the same. Good luck.
That's what we call justice.
This next case is one of the very reasons of why I place Judge Stevens as one of the best judges on the bench. As just when you think all hope for justice is lost, Judge Stevens arrives with destiny.
Bill Hernandez, that's you?
Yes, sir.
Present. In summary, this indictment alleges that on or about March 10th, 2021 in Jefferson County, Texas, you committed the second-degree felony of indecency with a child. Do you understand what you're charged with here?
Yes, sir.
If convicted, you face a term of not more than 20 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
An agreement has been reached where you would be pleading guilty, prosecuted for the lesser included offense of what is the offense?
Indecent assault. Class A.
What's the section number, please?
20.
I got 22, I guess. Indecent assault, 22.012. A person commits an offense without the other person's consent with intent to arouse or gratify the sexual desire of any person. Person touches the breast of another person. This is a Class A misdemeanor. So let's go back. So the punishment range is not second-degree felony. It's Class A misdemeanor, right?
Judge, I'm sorry. I fill those out based on the allegation, the indictment, on what role they're leading to.
All right. The agreed to that you would be pleading guilty to lesser included Class A misdemeanor indecent assault. which carries with it up to 1 year in the county jail and or up to a $4,000 fine. Do you understand the punishment range?
Yes, sir.
The agreement is that you would be placed on deferred or unadjudicated probation for 2 years. Is that your understanding of the agreement?
Yes, sir.
Also fined $500.
Yes, sir.
How do you plead to this Class A misdemeanor, lesser included offense under this indictment? Indecent assault, guilty or not guilty?
Guilty,
You know what you've been charged with? The indictment's been read to you. You've read it. You were guilty of the crime charged in any lesser included offenses. How old was the child? 10 years old?
Yes, sir.
So the only difference between this and the second degree felony of indecency with a child is the fact that y'all just dropped the age of the victim, right? As an element.
Yes, sir.
Everything else is the same.
Yes, sir.
Okay.
This is the moment where you can see that the plea deal that has been worked out is weighing heavily upon Judge Stevens' mind. And it's starting to build. What's starting to build, you may ask? Well, that would be the look of disgust.
All right. Anything else?
Not for much.
Okay. It looks like sex offender registration is not required yet.
It's not mandatory, no, sir.
And it didn't get passed in this term, I guess.
No, sir. Not to my knowledge.
Because the statute says it's sexual offender registration is not required, and then it's in parentheses yet. So apparently, for whatever reason, they elected not to. The legislature elected not to change that other code. Well, anything else?
Not for much.
All right, and the defendant has entered his plea of guilty to this Class A misdemeanor. Is a pre-sentence report waived?
Yes.
Anything else to add? If not, I'm going to find Mr. Hernandez, you have pleaded guilty to this Class A misdemeanor, the lesser included offense of what is referred to as indecent assault. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. However, I am going to follow this agreement, defer any finding of guilt, and place you on deferred or unadjudicated probation for 2 years. You are fined $500. There will be terms and conditions of probation, which are normal and customary for this type, a general type of offense, even though I'm wanting to go to sex offender classes and other things like that, that are normal and customary for other types of the offenses. And especially in light of the fact that the complainant was 10 years old at the time of this event. There will be other terms and conditions of probation which are normal and customary for this. Now, you're also going to do 180 days in the county jail.
Run from it, hide from it, do what you will. But in the end, destiny will always arrive.
This is a crime of indecency. A 10-year-old child is victimized. You're going to pay a price for irreparable harm to a child on my watch. I just wish it was more. You took advantage of a 10-year-old more than once, according to the probable cause affidavit. And except for everybody just dropping the age, it's a second-degree felony. Plus mandatory reporting requirements for life, I believe. Otherwise. So what this court can do in managing the fair and appropriate remedy that I guess we can assess, although how do you take back the harm to a child? There is no way. You took advantage of a child. I have no sympathy for you. I have sympathy for the child. You took advantage of a 10-year-old child. Shame on you. You're going to jail immediately, 180 days, as a condition of this probation.
Your Honor.
Anything else?
Yes, Judge, if I may, considering that he's employed currently, will the court allow us to break that up in some way? I don't have something to proffer to the court right now, but I would at least like to ask the court to,
Let me just say,
to consider.
Mr. Kelly is one of the most wonderful people I know. And he's a wonderful attorney, as well as just being a very fine, great man. He has children, and I know what he thinks. I know what we all think. You didn't give this child a chance to get ready for your assaultive behavior. And you did this more than once. And I have no sympathy for you. I'm not going to work on your terms, in spite of the fact I would do almost anything for Mr. Kelly. This doesn't have anything to do with Mr. Kelly. He's trying his best to help you, but he cannot undo your terrible misdeed. It was an unnatural act you performed on a child. Shame on you. You're going to jail. The most I can put you is 180 days. And that's what you're getting. That's what we call justice under these circumstances. Unfortunately, we can't undo the assault that you performed on a 10-year-old child. Shame on you. Anything else? That's, in all due respect, if it was any other kind of circumstances, Tom, but I feel sorry for that child.
And there it is, ladies and gentlemen of the jury, the look of disgust. And Judge Stevens pulls it off perfectly. So that brings us to the end of this episode. Thank you for staying with me. As always, I do so appreciate you guys helping me build my little channel. Please remember, if you want to enter the competition, I have placed the episode to watch on screen now for you all. Please subscribe and see you all soon.